In this video, I'll discuss school districts' social media policy and school employees' First Amendment rights. Does your employer's social media policy overly restrict your ability to use social media? Does the social media policy define what it means to be a matter of public concern? Does the social media policy include a provision that informs employees of confidential information? How can school districts, as public employers, develop a social media policy that doesn't violate school employees' freedom of speech? I suggest you find the document of your employer's social media policy before watching the rest of the video. In the previous video, I introduced the Pickering decision in 1968. In that case, the U.S. Supreme Court applied the standard of actual malice from the New York Times Company versus Sullivan, 1964. The actual malice standard makes it extremely difficult for a public figure to win a defamation lawsuit in the United States. The Supreme Court also established a balancing test to determine whether the First Amendment protects a public employee's speech. A balance must be achieved to protect a public employee commenting on matters of public concern and a public employer's concern in promoting workplace efficiency. Later, the Supreme Court further elaborated on the applicable requirements of public employees' freedom of speech, holding that government employees enjoy First Amendment protections only when speaking as private citizens and on matters of public concerns. More than 50 years have passed since the Pickering decision. How to apply the Pickering decision to government employees' speech on social media today? Here I offer 3 principles. First, school districts' social media policies should avoid including provisions that prohibit employees from posting anything negative at all. Public employers cannot try to control their employees' online speech by developing overly restrictive policies. Here is a case of a police department social media policy. In April 2013, the police chief issued a general order revising the department's social media policy. The revised policy prohibited in sweeping terms the dissemination of any information that would tend to discredit or reflect unfavorably upon the department or any other City of Petersburg department or its employees. The central provision of the policy, which we will refer to as the negative comments provision, states negative comments on the internal operation of the Bureau or specified conduct of supervisors or peers that impacts the public's perception of the department is not protected by the First Amendment free speech clause in accordance with established case law. Another provision, which we label the public concern provision, specifies officers may comment on the issues of general or public concern as opposed to personal grievances, so long as the comments do not disrupt the workforce, interfere with important working relationships or efficient workflow, or undermine public confidence in the officer. The instances must be judged on a case-by-case basis. The policy strongly discourages employees from posting information regarding off-duty activities and provides that violations will be forwarded to the chief of police for appropriate disciplinary action. On June 17, 2013, an off-duty police officer posted on his Facebook criticizing a department policy. More than 30 people liked or commented on this post. Another off-duty police officer posted his comment on social media. Later that day, the first police officer responded to the second police officer with a comment of his own. The second police officer then replied. Among those who liked or commented on the Facebook postings, most were current or former department officers. The two officers' supervisor learned of the exchange on social media and notified the police chief of the issue. The chief determined that the statements in the police officer's Facebook postings violated the department's social media policy and instructed the sergeants to discipline the officers. In the disciplinary action forms, the department stated that the two police officers' comments violated the negative comments provision. Each of the officers received an oral reprimand and 6-month probation, but they were advised that such discipline would not affect their eligibility for promotion. Several weeks later, the police chief changed the qualification for promotion. The new protocol excluded any officers on probation from participating in the promotion process. Accordingly, when the two officers applied for open sergeant positions, the department notified them that they were ineligible for the promotional exam. On October 1, 2013, the two police officers sent a letter informing the city that they intended to challenge the disciplinary actions. Shortly thereafter, the two officers were the subject of several complaints and investigations within the department. Based on the findings, the police chief decided to fire the first police officer, but the officer resigned before receiving the notice of his termination. The Fourth Circuit held that the police department's social media policy was unconstitutional and overbroad. The court stated the threshold question in this case is whether the department's policy regulates officers' rights to speak on matters of public concern. There can be no doubt that it does. The restraint is a virtual blanket provision on all speech critical of the government employer. The explicit terms of the negative comments provision prevent plaintiffs and any other officer from making unfavorable comments on the operations and policies of the department, arguably the paradigmatic matter of public concern. The court noted the astonishing breadth of the social networking policy's language. The policy seeks to prohibit the dissemination of any information on social media that would tend to discredit or reflect unfavorably upon the department. In particular, the negative comments provision proscribed negative comments on the internal operation of the Bureau, which could be just about anything, or on the specific conduct of supervisors or peers, which again could just be about anything. And the speech prohibited by the policy might affect the public interest in any number of ways, including whether the department is enforcing the law in an effective and diligent manner, or it is doing so in a way that is just and even-handed to all concerned. The department's law enforcement policies could well become a matter of constructive public debate and dialogue between law enforcement officers and those whose safety they are sworn to protect. After all, government employees are often in the best position to know what ails the agency for which they work, but this policy will cut short all of that To repeat, it squashes speech on matters of public import at the very outset. Moreover, the court noted that the police department failed to satisfy its burden of demonstrating actual disruption to its mission to fulfilling public responsibilities. Apart from generalized allegations of budding decisiveness and claims that some patrol officers sought shift transfers, police chief presented no evidence of any material disruption arising from the two officers or any other officer's comments on social media. The court did not deny that officers' social media use might present some potential for division within the ranks, particularly given the broad audience on Facebook. But the speculative ills targeted by the social networking policy are not sufficient to justify such sweeping restrictions on officers' freedom to debate matters of public concern. Second, school districts' social media policies need to define what it means to be a matter of public concern. If a public employee's speech is purely personal, it is not protected by the First Amendment. However, if the speech of public concern, according to the Pickering decision, courts must balance the interests of the employee as a citizen in commenting upon matters of public concern and the interest of the state as an employer in promoting the efficiency of the public services it performs through its employees. The Pickering decision held that the public employee's speech on matters of public concerns is protected by the First Amendment. School districts' social media policies should include a provision that explains speech discussing matters of public concern is protected. The district can include examples of topics which would be considered as a matter of public concern. This would protect both the employer's and employees' interest by leaving both open to demonstrating that an employee's speech does or does not discuss a matter of public concern. What is speech of public concern? Speech involves a public concern when it involves an issue of social, political, or other interest to a community. The Supreme Court has directed courts to examine the content, form, and context of a given statement. Again, I use the case Liverman versus City of Petersburg 2016 as an example. In this case, the police department's social media policy included a provision that permits comments on issues of general or public concern, so long as the comments do not disrupt the workforce. Regarding this provision, the court noted that this portion of the policy offered a narrow restriction. But the court stated the milder language in the single provision does not salvage the unacceptable overbreadth of the social networking policy taken as a whole. Moreover, the court stated that each veteran officer grounded his statements in specialized language and expressed a general concern of the inability of the department to carry out its vital public mission effectively. Whether plaintiffs were correct or not in their views is not the issue. The matter they addressed was of more than personal import. We thus have no trouble finding that plaintiffs' Facebook comments, which addressed risk posed by the department's inexperienced supervisors, raised issues of public concern. Third, school districts' social media policies need to specify that confidential information must remain confidential. In education, what types of information are confidential? The Family Educational Rights and Privacy Act requires schools and school districts to protect educational record. Here, educational records means data elements that are directly related to a student and maintained by an educational agency or institution or by a party acting on behalf of the agency or institution. Extra care must be taken to protect non-directory student information. Your social media posts must not include students' courses taken, disciplinary actions, grades, schedules, student numbers, or test scores. Personally identifiable information must also be protected. Your social media posts must not include student names, personal characteristics, or information that would make the student's identity easily traceable, name of student's parents or other family members, or social security numbers. In this video, I offered 3 principles of school district's social media policy. Does your school district's social media policy overly restrict your ability to use social media? Does the social media policy define what it means to be a matter of public concern? Does the social media policy include a provision that informs employees of confidential information? Now it is time for you to apply those 3 principles to analyze your district's social media policy.